Welcome to Navigating Complex Divorce and Parenting Issues with attorney Melanie Walls.
Welcome to Navigating Complex Divorce and Parenting Issues with attorney Melanie Walls. Melanie is an OSBA certified specialist in family relations law who regularly handles complex financial matters involving business ownership, professional practices, and substantial investment portfolios. I'm Leanne Lyon, and today we're exploring what makes a high-asset divorce unique and the financial details that shape these cases. Melanie, when a divorce involves significant assets, what are the core issues that make these cases more complex than a standard property division?
Well, I think one of the things is you need to bring in a team. This just isn't the lawyer handling the case. You want to collaborate with other professionals, such as a forensic accountant. You may want to get a financial planner. You may need to get a business valued. If it's a family-owned business or one spouse has an interest in a business, you've got the business to value. They could have a complex compensation package that you need to look into more closely. They may have multiple investment accounts, which is where a financial planner as a consultant comes in, as to how best to divest some of those assets into another account for the other spouse. So it's not just your simple, the attorney gets the file, they do some discovery, they get the financial documents. It's more of a team approach when you get to the complex asset cases.
Well, you mentioned business ownership, and professional practices require especially careful financial analysis. What information is most important to gather early on to understand the true value of a business?
That's a great question. You want to do a deep dive into the financials. You want financial transparency, which is going to include requesting several years of tax returns for that business, profit and loss statements, balance sheets. You want the business bank records and bank statements. If it's an LLC, you want to see an operating agreement. If it's a corporation, you want to see all the corporate documents to make sure you understand how it's structured and the spouse's ownership interest in that business.
Well, high-earning spouses often receive compensation through a multitude of areas: stock options, deferred income bonuses, profit distributions. How do these components typically influence, support, and division discussions?
So deferred compensation is an asset of the marriage. If that money was earned during the marriage and set aside by that spouse, that is an asset subject to division. Bonuses come into play for support. For spousal support, the court could order that spouse to pay the other spouse a percentage of that bonus on an annual basis. And as far as child support goes, on the worksheet, it's a 3-year average of those bonuses because those fluctuate. You don't know what they're based on. Are they based on how the company performs? Are they based on how the employee spouse performs? And those can fluctuate, which is why the court does a 3-year average on the child support worksheet. Stock options are even more complicated because there's a twofold piece to stock options. I was involved in a case back in the 90s where the father obligor for child support earned stock options. And his position was they're not income for purposes of child support. And that went all the way up to the 12th District Court of Appeals, and they determined that, yes, they are income for child support purposes, because otherwise the obligor spouse could put off exercising those options until the child emancipated instead of exercising them when they become due. Usually, 3 year or 5 years, you're able to exercise the stock options once they're granted. Now, they're also an asset in divorce. And that gets complicated because while they may have been granted to the spouse, they're not exercisable until that 3 or 5 year period. So you really have to make sure the attorney is familiar with stock options and knows the necessary language to put in your agreement. Sometimes you have to have the employee spouse hold those stock options in trust for the other spouse until they're exercisable. Then that spouse has the option of saying, yes, I want to exercise them, or no, I don't. And then they would revert back to the employee spouse, because there are some financial considerations when you go to exercise those stock options. So that's a very complicated piece of the divorce process when they have stock options.
Sounds like it's especially important to have a great team that understands all of that.
Absolutely.
Can you describe a situation where reviewing business records, tax documents, or investment statements highlighted something that required a closer look as the case unfolded?
A lot of times you'll see, especially in small or, family owned businesses, where there's not a clear line between business expenses and personal expenses. For example, you have a business owner using the business credit card to take the family on vacation, or putting, family dinners on that business credit card. And you need to ferret out those expenses, because those are not business expenses. And that actually becomes income to that person, because they're running the business expense, the personal expenses through the business. So that plays an important role on, what is their actual income. They may pay themselves a 1099 or a W-2 of $100,000. But when you look through the business credit card statements and bank statements, they're running the boat payment through the business, or they're running, the kids' sport expenses and family vacations through the business. Well, guess what? Their $100,000 income just bumped up to $150,000 once you go through the financials and find all those expenditures.
That could be a big tax hit in that case.
Oh, yes, very much so.
Investment portfolios can include retirement accounts, brokerage accounts, restricted stock, and alternative investments. What tends to matter the most when determining how these should be divided?
A couple things matter, and that's again where the team approach comes in. You want your client to also consult with a financial planner. What makes the most sense for that client? Should they take from their spouse's IRA? Should they take from their spouse's 401k? If they have a substantial joint brokerage account, what makes the most sense to transfer to that spouse? They need to talk about their long-term and short-term financial goals with that financial planner, and then give their lawyer a game plan of what makes the most sense. They may not want any stock. They may want some mutual funds. What are we going to do with this money when it's transferred over? So again, having an attorney who collaborates with financial experts is extremely important in these types of cases.
Tracing separate property becomes especially important when substantial assets predate the marriage or were inherited. How do you approach situations where the documentation is incomplete or maybe unclear?
Well, there was a case that came out this week in the 12th district that addressed that very issue. It was a long-term marriage. Husband had an account that was 30 years old. No one has bank records from 30 years ago. So, what are you going to do? Husband testified he was the only one that had access to that account. He was the only one who could put money in that account. An interesting twist in that case is he was military, and the bank was on the military base. So obviously his spouse couldn't get on the military base. So he was the only one who could deposit money into that account. Wife testified, I don't think that it was just his money going in there. I think he put marital funds in there. And the court found in wife's favor and deemed it marital, because husband could not come up with the bank statement to show what he had in it on the date of marriage. I mean, and that's just not something you can go back 30 years. I think it's important during a marriage. I see this a lot with real estate. Two people get married. They both have separate homes. They sell those homes and buy a marital home. Well, you need to keep that paperwork to show, your closing statement from the house you sold, the closing statement from the marital residence. So you can show, hey, when I sold my house, here's the closing statement. I had 50,000 that I got from selling that. And then here's the statement for the marital residence where you can see we put down 50,000. Now, if you don't have that closing statement, it's going to be difficult to come up with it, 15 years from now. And, the courts are holding to the line of, if you can't document it, you don't get it. So if the other spouse doesn't agree that you put that 50,000 down and you don't have your closing statement or a canceled check or any document to show that, well, guess what? It's going to be marital, and it's not going to be your separate property where you get that first 50,000 off the top of the sale proceeds from the marital residence. And it's unfortunate, but you can see the court's point of view too, that, hey, anyone can get on the stand and say, they put 50,000 down and they had it before the marriage. We need some documents to prove that.
Well, tax implications can significantly affect the net value of a settlement. What tax considerations do spouses need to be aware of when dividing large assets or transferring business interests?
I think something I see in my practice a lot is when you have a spouse that wants to retain the marital residence. And let's say they owe the other spouse $250,000, but they don't want to refinance, especially now. I mean, people have 2.75, 3% interest rates. They don't want to refinance to 6 or 7%. So what they want to do is say, hey, I'm keeping the house. I know I owe you $250,000. I'm going to give you $250,000 out of my IRA or my 401k. Well, guess what? Those aren't apples to apples. That's apples to oranges, because $250,000 cash is a lot different than getting an extra $250,000 from your spouse's 401k. Because unless you're, over 59, you're going to get a penalty if you withdraw that. And there's also tax consequences. So when you say, okay, I'm going to do it that way, but guess what? You're not giving me 250 from your 401k. You're giving me 280 because of the penalties and tax. Don't hold me to the math. Obviously, I'm not doing that. I'm not calculating it. I'm just giving you an example. So, instead of 250 from your 401k, I'm taking 280 or 285, because then that equals the 250 cash I should have received. Because if I take it out, then that 30,000 covers the penalties and taxes, and I'm still getting 250,000 cash in hand. And I see a lot of people make that mistake. They think 250 and 250 is the same thing, and they don't take into account the tax consequences and the penalties.
And that's where you want that forensic accountant in there doing all the math on you. Maybe that refinance would make sense, but maybe not.
Right. You're exactly right.
So high asset cases can often involve multiple professionals, like you said, CPAs, appraisers, financial advisors, or forensic accountants. How does collaboration among that team help create a clearer overall financial picture for the court?
Well, you want to make sure that you have all the information that you possibly can. Typically, your attorney is not going to go through 5 years of financial documents and generate reports. That's why you need someone to value the business. They generate those reports and go through it. And they can look at, compensation. What is the spouse's actual compensation? What is this business actually worth? That's where it's important to have a team of experts, such as, like you said, financial planners, business valuation companies. Typically, when I am going to value a business, I give my client the choice of three that I use, and I have them reach out and contact them because it's their case. I want them to feel comfortable with the person or the company that's going to be doing this work. So, and then I have them pick, of the three, which one they want to value the business. Same, with a financial planner. I mean, this may be somebody that your client is going to continue to use for their financial planning for the long term. So again, there's two financial planners that I work with. I give the client their contact information and have the client reach out to them. I mean, sometimes the clients come in and they have a financial planner and they're just going to continue to work with that person. But a lot of times you got to remember the spouses are using the same financial planner. Do you really want that person advising your client and their spouse? You really want your client to go with a neutral third party as far as the financial planning. So all of that factors into it.
Well, as we wrap up here today, when spouses want to preserve a business or professional practice, what types of solutions can help maintain continuity while still achieving a fair overall division?
That gets a little complicated, and it's on a case-by-case basis. If you have two spouses running a company, the court wants parties to completely financially divest themselves. And it's very difficult and rare, if ever, that I see where two people run a company and say, yeah, we want to continue to run the company after we terminate our marriage. It's just not feasible in most cases. So, one person that's the primary of the business usually keeps it, and then they have some sort of a buyout of the other spouse. It's a very difficult thing to navigate when you have two spouses running a business.
Well, that wraps up today's episode of Navigating Complex Divorce and Parenting Issues with attorney Melanie Walls. To learn more about Melanie's practice or request a consultation, visit melaniewallslaw.com. Thanks for listening, and remember to like, leave a review, and subscribe to the show so you catch every episode. Thank you, Melanie.
Thank you, Leanne.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.